We now have the pleasure to welcome Professor Mauricio Duce. Mauricio Duce is professor at the University Diego Portales in Santiago, Chile. Professor Duce is also co-director of the Master's Program in Criminal Law and Criminal Procedure and director of the Program for Procedural Reform and Litigation. And he served as the secretary to the technical team that drafted the bills that comprised the Chilean criminal procedural reform, and has been an advisor of the Ministry of Justice in this area. So his paper will be entitled Prácticas probatorias y riesgos de condena de inocentes, una visión empírica. Por favor.
Well, hello to everyone. And I would like to say, as everybody has, thank you to the organizers for this invitation. And, well, thank you, Jordi and Carmen, as representatives. Warm and such great people. I'm very happy to come here to talk to you about something I work on in Chile. Work I think can be relevant and important for people from Latin America, but also from other regions of the world. I think that in this third day of the conference, we see very clearly that error is a possibility we have to live with, and that the system of criminal justice would also have to be used to the possibility of mistakes happening. So the natural question is, well, fine, well then what's the problem then of accepting something that is natural, that we make mistakes? And there I think that evidence, well, that has been generated specifically in the last 20 years gives us very interesting clues in order to face this question. First, evidence is telling us that the mistakes made by the system, the legal system, are kind of more frequent than traditionally people thought. Yes, it seems that we make more mistakes than had been assumed, that it's not the same to make a mistake every 1,000 cases than one every 100 or one every 10. Second, and we see this on the basis of accumulated evidence, when criminal justice systems make a mistake, this has a catastrophic effect on the person suffering from that mistake and also the environment of the person. And a third thing that I'm going to be focusing on in my presentation has to do with the fact that many of us, well, we know that many of the factors generating error and mistakes that contribute to mistakes happening are produced by the criminal system itself. So if we knew about this, we would be able to prevent the mistakes. And I think this is a really fair aim of any system, to try and prevent and reduce mistakes and errors to the minimum. It's being naive to think that no mistakes are going to be made ever. So I think this is a really quite a possible aim, and really a moral imperative for any legal system in a democratic society. But of course, for this, right, in order to have policies for prevention and efficient mistake and error reduction, we have to have more empirical evidence than we do have nowadays. We still don't really understand well why mistakes happen, what the dynamics are behind these mistakes, and empirical evidence, as I say, in the last 20 years has grown significantly, but even then we don't know all that much. And I think it is essential, crucial, that we have strong research in this direction. And there is where I place my presentation of today, and it's really my research project. And I want to share it with you. What I'm going to be tackling is to try and prove or show you the evidence consolidated in compared legal practice, especially in the US, because my opinion is that in the US is where more empirical evidence has been gathered about this. But not only the US, there are many other countries giving us some clues as well. And then I'll show you the results of my own research in Chile, especially in two practical areas where there are many probatory areas: the use of expert evidence and also eyewitness identifications. So if I have time and I do okay, I'll also try to end with some reflections on the basis of the empirical information I will tell you about. So how to face the problems that I'm going to try and identify. Let me clarify something first of all, so that we don't have conceptual trouble. We've talked a lot about errors, yeah, a lot. And we know that there are different types of errors, yeah, and this has been mentioned in more presentations. But the errors or mistakes I'm going to be focusing on are when innocent people are condemned, when the justice system is sentencing someone who is innocent of that offense. But I'm also concerned about the type of error that people are starting to study now. And for this conference, we could say it's a near miss error, okay? What are these near misses? Well, they are situations in which the criminal prosecution system has started the prosecution of somebody. That person is imprisoned or their rights are restricted, and then after some time, that person is superseded or acquitted, and then that person finally is not sentenced. And then somebody will say, but that's not an error, it's a success of the system. But what we've learned and what evidence tells us is that many of these cases, yes, indeed, could have been solved much earlier. So then the damage caused to that person could have been prevented, because all the elements indicating that it was an erroneous prosecution were there. So with better diligence or more efficiency, the case could have been solved much earlier. Brian Forrest in the US said something like that these cases produce devastating effects as well for the person who is prosecuted. I mean, it's not enough to say, listen, yes, it's been a success. Sorry, yeah, I spent a year without my freedom because you made a mistake. I mean, that's what it is. So it's also a mistake. It's an innocent person suffering. Second clarification, I don't like to talk about judicial mistakes as the way people refer to it. These are mistakes of the criminal justice system. Because we see that these errors happen because of the confluence of a number of factors and actors. It's not only the judges. I mean, obviously, when an innocent person is sentenced, yes, of course, the consolidation comes through the sentence of the judge. But I mean, everything is telling us that this error happens because there are, police agents and prosecutors and judges and a number of factors. I talk about probatory practices. I'm not an epistemologist. I'm not a philosopher. I don't want to create new sophisticated concepts. I just talk about probatory practice as a descriptive term that allows me to include there a number of different practices of the different actors in the system that are associated to the production, incorporation, litigation, and assessment of these means of evidence. And for those people who don't know about the Chile legal criminal system, I'll give you just a summary, but I'm giving you an overview. The criminal system in Chile was radically reformed in the year 2000, and the reform meant substituting an inquisitorial model, adversarial, very orthodox, and it was substituted by a system that now I will provisionally define as accusatory. And there is a specificity. The specificity is that in the oral trial session, it's pretty adversarial, although the organ deciding the case is a panel with 3 professional judges. More or less, well, similar models have been established in most countries in Latin America in a huge process of reform that was started as of the mid-80s. And that's why research in Chile can be pretty useful for my Latin American colleagues. So what was my research about? Well, just an overview. I'm going to be very general. Please feel free to ask me later on. Look, it's very difficult to work on this. Professor was asking, how can we kind of gain access to knowledge about this? Well, I had to design a complex methodology with many steps, and one first central element is an empirical qualitative exploratory study with interviews to expert persons of the metropolitan region of Santiago, the capital of Chile, where 40% of the population and 90% of the problems of the country happen. It's where I live too. Then as well, I studied 2 databases of cases with errors in which innocent people were exonerated by the Chilean court, close on to 50 cases. I studied all the cases to see what had happened. And there's also this is a database that the Public Prosecutor's Office has analyzed as well, of near misses. That's 60 cases. Third, obviously, I got all the statistics available of the system. In Chile, institutions really generate and produce a lot of statistics, and they publish them, but also all the studies in journalism, literature, academic, about practices of the system. I also asked, a lot of access to information. And finally, with some of my students of my master program, I designed a methodology to review sentences dictated by, in oral trial sessions in the metropolitan area on sexual offenses, all the sexual offenses solved by those courts in 1 year, and also health cases and cases, third study, in which there was eyewitnesses. So I wanted to reconstruct what had happened during the trials. And we also took a control sample. My students took in 10–15% of all those cases, listened to the audio of the whole trial to see that what had been written in the sentence was really reproducing the reality of what had happened during the trial. So I'm telling you that obviously this methodology has limitations, I guess, but I mean, well, we can say that there was pretty good information as the basis for my research. If somebody thinks that this doesn't represent reality or doesn't go to generate plausible hypotheses, well, bring me more data. Because I mean, and if those data show that I'm wrong, I'll be happy, because that means that we will know more about the way the system functions in reality. So, something to tell you about my starting point. Nowadays, we know that errors are more frequent than what intuitively we had thought up till now. But what do we know? Are they so frequent? Do they happen so often? Do we have empirical information about the frequency of error? This is extremely difficult to know. But I do identify, I think, two efforts on compared research. First, statistical evidence. In the US, there are many Reisinger Gross, there are many research projects. The last one, 2014, published in the Proceedings of the National Academy of Science. And basically what they try to do is to determine an error rate. So database, then they analyze and identify how many cases, so they have statistical error rates, and that's what Gross did. This is debatable methodologically, but this at least is the most solid methodological attempt. He took 40 years of cases in the US, there you have the dates, of cases in which, sentences with death penalty, and he was able to establish in that sample 4.1% had person condemned to death. And I was surprised. 4.1 means that out of 100 persons, slightly more than 4 are innocent. And death penalty, of course, is the most serious. I mean, it's where most effort is invested and more is done before you get to that kind of sentence. Second effort, anecdotal evidence, I call it. In many countries, the cases of innocent people condemned are part of some database of exoneration because of the different resources. We have the habeas corpus in the US and what have you. And here there's a lot of information, but it's anecdotal. It's not systematic. Only those cases that have kind of gone on to revision. Let me give you an example. When I started my research, I was told, listen, well, some Chilean friends said, listen, your research is going to fail. Why? Because, in fact, in Chile, there are so few cases of innocent people condemned. You can count them with the fingers of one hand. And some people said, yes, only kind of with just 2 fingers. So you won't have a database, I was told. But listen, in my research, and only on the basis of the last 10 years, cases produced in the accusatory system, I found nearly 50 cases of innocent persons sentenced that were later on exonerated by the Supreme Court. If you analyze the Criminal Case Review Commission in the UK, or the database, we have impressive, one of the National Registry of Exoneration is incredible, more than 2,200 cases registered since 1989. These are figures that are quite impressive. However, all this indicates then that errors are more frequent than what we had thought. But where there is agreement, because all this is partial, of course, is that all methods are estimating, really, they are underestimating the real figures, because we have to count the types of offenses, and most authors working on this think that the kind of minor or lesser offenses have maybe a higher rate of error. And now there's a lot of work being done on minor offenses, for example, plead guilties, yes. On there, well, the idea is that the problem would be huge. Unfortunately, we have no information about those other not so serious offenses, so just imagine. But in the case of anecdotal evidence, there's also, well, the idea that we have only the tip of the iceberg here, because there are structural hindrances that don't let us go to analyze exonerations, because it means a lot of money. It's very expensive for a person who's been sentenced to get a revocation, because typically the standards demanded by the mechanisms in the different countries are really sophisticated. So, for example, that the sentenced person has to accredit his or her innocence. They not all in the circumstances in which they can do that. And, well, so just imagine, it means that we have many more errors than we thought. And whatever way you count, you're not going to be counting near misses. And we know now that that's even a higher number than the errors themselves. So, fine. More research is required, more data, but with what we have, which is not a lot, and for anybody living in the world saying, well, yeah, 1 in 1,000, listen, I'm sorry, the figure is huge. We have much more information, however, regarding the factors that increase the probability of generating erroneous decisions. I would say that in classical literature, there are 6 factors. You have them on the slide. If you see the 4 first, they have to do with probatory practices of criminal justice systems. The last 2 have to do with defects of institutional functioning of the prosecution bodies of defense. This literature has been criticized in the last 2 years because of methodological bias. How did the authors determine this? Well, through studying cases of innocent people who were condemned. So then, of course, all this could pose a bias on the basis of what is it that's influencing there. And that's why a very interesting research has been developed applying social sciences methodologies. It's been John Gould, Richard Little, and others, published in 2013, 2014. And they compare cases of innocent people condemned with comparing with near misses. And the findings tell us that factors are very similar in both. Ratifying, of course, previous findings, but adding other things that hadn't been well mapped. In this other literature, for example, that the age is also a factor increasing probability of being sentenced, that the previous antecedents of the accused have an impact on factors like these. All the research then agrees in that in these error cases, there's not only one factor, but usually a whole set of factors associated that explain the end result. But in all this literature, there's quite an agreement in that the probatory practices regarding using expert evidence and also with eyewitness identification, well, these are really relevant factors. So I suggest that we see, what is it we know about this? Let's go about it. Well, expert evidence and errors. Let me skip a couple of things here. So let us start by evidence. When you review the Innocence Project or the Latin Registry of Exonerations, we see that this is a factor that tends to happen in a lot. Somebody mentioned it during the first day of the conference. 45% mentioned the problems with expert evidence, and in other databases, the statistics vary. But for example, in England, there's a lot of information. We talked about recommendations, but we do know that there are high-profile cases in which in fact, the expert evidence was misused. In Canada, there have been very interesting developments. There are 2 reports coming from the Federal Prosecutor's Office in 2004 and 2011, where they mentioned that this was a huge problem. So as I say, there's evidence in dissimilar countries like Germany, China, it's happening. So what type of problems? Let me mention 5 problems that seem to be very clear on the basis of the evidence available, and we'll see about things locally in Chile. First, and my thanks to Gary and Marina, because I think they clarified it very well in the first day of the conference. Unfortunately, our criminal justice systems tend to, well, use not very reliable and not very good evidence. Junk science, they call it in Anglo-Saxon countries. Yeah, I mean, well, the person coining that phrase said it was equivalent to the one own's reflection in the mirror, yeah, because you see a reflection and it's the same form, but nothing of the substance. So junk science is the form is apparently science, but the substance isn't. And thanks to the National Academy of Sciences work, we know that much of the forensic science that are used by legal systems are not as reliable as we had thought. And this is part of the discussion in many other countries as well. What are my findings in Chile? Well, one first finding is precisely that, yes, we had problems with the reliability and quality of evidence. For example, in sexual offenses, in the sample we reviewed, I was able to determine that 55% of the evidence submitted had to do with psychological evidence on credibility, what we call credibility evidence. And that is a methodology that is known as SBA, that is really hugely questioned, both on the basis of methodology, it's kind of psychology, and, well, in fact, in countries like the US, it's only admitted exceptionally, although in some Latin American countries and some in Europe, such as Germany, they use this system quite a lot. But I also discovered, and I'm giving you information, that the lab of the main lab of the police corps in Chile, I asked them, what evidence did they work on in their lab? Well, I discovered 11% had to do with fingerprints. And now, once again, thanks to Gary, I don't have to tell you how problematic fingerprints can be. But I also detected bad quality problems linked with the fact that the reports that experts write have problems regarding the quality of the explanations and the justification of the methodology they use to get that evidence. There's really no explanation practically about the methodology they follow, and defects as well regarding the clarity of the explanations, and the reports of the experts emphasize the conclusion. So a lot of conclusion, but hardly any justification of how you get to the conclusion. So things that don't tally. I mean, I've not got time, but I can tell you about an important study that's just been published in Chile. They carried out a survey to more than 140 judges, 4,000 lawyers, 350 experts, all in criminal law, and they all kind of answered the survey, and you would be quite surprised to see what the result was. I mean, people don't think that things are happening as they should. Anyway, I was rather disheartened with this. Quality and reliability, then, of evidence depends partially on who carries out or works on that evidence. And what I discovered is that in some areas, for example, in forensic psychology or forensic medicine, there were serious problems of specialization of the experts that work on the evidence. What I discovered is that there are areas in which there's practically no specialization, or even when there is, they don't find people with the skills necessary. And this has to do as well with the economic incentive of the system. It's difficult to retain specialized people in those public institutions working on evidence. So what I could detect is that those experts working on evidence might be, well, recently graduated from the Faculty of Medicine or Psychology, because, of course, what they are paid there is good for them. But when they get older and specialize further, they want to get better paid and go elsewhere. To give you, I mean, figures. I asked the Legal Medical Service of Chile, the Public Institute for Evidence, to give me data. And let me tell you, the forensic sexology unit of the capital that produces 60% of the evidence, what they call forensic sexology, for sexual offenses, analyzing victims and so on. So of the 11 persons of the unit in June 2016, 7 had no specialty. 2 did have it, and 2 were gynecologists. And those are the main specialists. And then when I talked with other people in Chile, they said this is a problem because, of course, the interpretation of the expert in this discipline is crucial to get to the result. And the interpretation has to be based on training, experience, and research. And obviously, most of them hadn't been trained. They had a bit of experience. But I mean, frankly, the experience of doing something badly many times doesn't make me become a good expert. And by the way, no research. Then this happens again in that survey of the Supreme Court. People perceive it this way, but funnily enough, with these surveys to judges and lawyers, but listen, the labs in Chile are very good. We think they're really reliable. And then I wonder, what objective indicator could we use to see how reliable the labs are? Because wearing a white overall doesn't really mean that you a good technician. So I asked the 5 main forensic labs in Chile, and I asked them about an objective indicator. I said, have you any international certificate, for example, ISO 17025, which is the standard for international accreditation of forensic labs? None. And I discovered that as well regarding updating of protocols and so on. Fine. So second bad problem. Even though one might present evidence that's of good quality and reliable, the findings of empirical research, especially in the US, coming from Garrett and Nathan, tell us that a huge, huge problem is that experts in trial tend to give what is called invalid witness or testimony. In fact, in 60% of the cases, we identified this problem. But what do they understand by invalid testimony? Well, basically 2 things. Well, something is being affirmed that is not supported by the discipline it comes from, or it's an affirmation that's empirical that cannot be really justified by that area of knowledge. And, well, for those that know the case of Sally Clark in England or Dr. Smith in Canada, I mean, what did I find in Chile? Well, on the basis of the methodology, it was very difficult to do research on this, but we had a lateral finding that was quite interesting, and it's the phenomenon I call the problem of experts who speak more than they write, as you see in the image. What is this problem about? Well, expert evidence is complex, at least in Chile, and I guess in most systems there are 2 elements. A written report that should be detailed and has to be so that people can work on it. And then the oral declaration of the expert, where the expert tells the court about, well, findings and so on. What I discovered is that what was relatively frequent was that the experts during the trial would talk about more things than had been written in the report. I don't mean language expressions or synonyms. No, no, no. I mean that they added or changed elements substantially. And in this way, of course, they were not complying with the quality controls that should be necessary. What's the relevant finding? That many judges tended to be very deferential towards this practice on the basis of funny conceptions as to what expert evidence is. I can tell you later on if you're interested. Third problem, the most obvious, yeah, possibly the one people think about first, and it's what explains that, evidence doesn't always work. Well, the bad behavior of the expert is the rotten apples, isn't it? You know, only a few in a basket, get all the apples to go rotten. Well, these individuals, well, they hide, they fabricate, they use the parties in a way they shouldn't, but people would think that this is just a small sample, that there are very few rotten apples in huge baskets. Not at all. 14% of rotten apples discovered by Garrett. But the tendency is to think that there are not all that many bad experts. So then the second dimension of the problem is what I think is worse, a systemic problem. Quite a lot was mentioned the first day. It is all the biases, the different types of biases that experts have that take them to make mistakes or follow an attitude that has nothing to do, in fact, with their field of specialization. These are cognitive biases that most human beings have. Some are, well, conscious biases because of the kind of information experts have access to. Others have to do with the way the system works. As I say, there are many authors that talk about different dimensions of these biases. And what did I find in Chile? I won't give you too much detail, but we do have rotten apples. Quite an important case was that the son of a senator was accused because he was driving under the influence, and then he killed someone. The first trial was cancelled, and more expert evidence was asked for in the body. It was discovered that an autopsy had never been carried out. Anyway, the fact is there was a contradiction. And finally, this rotten apple, yes, was sentenced later on in another trial because there had been a falsification of evidence. But these are only, cases that are made famous from time to time. But in Chile, we have a systemic problem. There's a very complex case, in fact, that's still happening that has proven how difficult it is. I mean, in Chile, we have 2 national police bodies, and they have labs, okay? And the largest police corps, the Carabineros, have a lab. And we've discovered that the experts, when they belong to a hierarchical institution that has Well, they tend to be very deferential to the person at the top of the hierarchy that's not necessarily a scientist, but somebody else. But that person sometimes reads and changes some of the conclusions of the report of the expert on the basis of something else. This is a problem. In Chile, it happens. This hierarchical system means that sometimes we're not as objective as we should be, and we give more importance to hierarchies in institutions than we do to scientific evidence. Fourth, compared evidence is showing us that there's another problem. We tend to give great value to the judge, but judges give too much weight to expert evidence that sometimes is based on things that are not reliable. Yes, there has been a questioning of the empirical basis of this, and some people here, well, Schauer and Spellman have mentioned it, but I think that we should analyze the foundations of expert evidence. In Latin America, even in Spain, there's evidence telling us that when judges assess the whole trial, well, this evidence can be a problem. And what did I find in Chile? Well, all the evidence gathered, yes, I see that judges give a lot of weight to expert evidence, both in my interviews with judges, they told me, but also the survey carried out by the Supreme Court. 86.1% of judges and 92% of lawyers think that expert evidence is very relevant for the final result of the trial. Then we know then that they give a lot of importance to expert evidence, but how do they assess it? And it's what we've been talking about today. Is it a problem of the training of the judges, or a cognitive problem? Can judges simply not do it, or can't they get there because they've not been properly trained? I think it's more, well, we'll see. But in fact, what judges point out themselves is that, well, very candidly, they told me that they are very concerned about this. They have a critical point of view of their own work, but they say they've had no training to, I mean, they've had thousands of opportunities to learn about update things in law, but nothing about science, nothing about the understanding of the main forensic disciplines. But even they said the parties don't help us. They don't give us the information we would like to have in order to have a good assessment. I'm skipping over the perceptions of the parties. This is ratified in the survey carried out by the Supreme Court. But furthermore, in the studies or the analysis of sentences in oral trials, I could see that judges, when they have to value or assess expert evidence, they rarely take into account whether the expert is as he or she should be, and they don't really analyze the type of evidence. So then see what happens. I mean, great weight is granted to expert evidence, but judges don't have the tools to see if the basis or the foundation of that expert evidence is good enough, and whether the expert, him or herself, is a good professional. So then the million-dollar question, what's going on? Finally, as to problems in the production of expert evidence, difficulties that have been described by compared analysis and confrontation. There's this myth that all these previous problems could be solved if during a trial we could intensely confront the expert evidence. What are the main findings? Well, that usually the persons in litigation really don't have the ability or the skill to control the work of experts, multiple evidence items. I mean, Gary, once again, I mean, he really was useful for me. I keep quoting. But a second way to go is the possibility not of directly confronting it through cross-examination or counter-interrogation, but rather through the presentation of contrary evidence. But of course, we are told it's not so easy to have counter-evidence, and one has to be very difficult and not place too much faith on that. And what did I see in Chile? The same thing. Despite the fact that there are many problematic expert evidences, the percentages of cases in which there is counter-evidence are very low, 23% in sexual offenses, 13% in health. And when I go to the actors and ask, why is this so? They tell me we don't have the tools. We don't know how to go about this. And we have a lot of work. We loaded with work. We've not got any time. This is time-consuming. We can't do it. And this happens as well in the results of the survey of the Supreme Court. But we could also discover in the analysis of sentences that in direct examinations, there is not much help either. Okay, so there's a problem. that is happening all over. And furthermore, what I was able to see, as compared evidence was telling us, is that usually the way counter-expert evidence is submitted is, well, not very much, as you see, very low percentages. It doesn't happen as much as it should. Let's go to the second part, eyewitnesses. I'll give you the image of an eyewitnessing event that I went to before I came to Spain. And despite the description said it's a middle-aged, thin guy with short hair, I was not recognized. But witness number 4, yes, went to prison. If not, I wouldn't have been able to come here to talk to you. So some of us were born lucky. Anyway, let me skip some things. I really don't have time. I'm going to be even faster. Let's see, eyewitnessing. It happens everywhere, in all criminal systems, and nothing is telling us that we'll do without this in the near future. But what does it mean? I'm referring to 3 procedures. What in the US is show up, we show up. So when prosecutors, usually police, show someone to the victim and says, or asks in a way, can you recognize this person? Second, the rounds in which there are many people, and then the victim is asked to select. And then the third method is the typical group of accused persons, where we do have a limited number of people, and one of them is a suspect, and we ask the victim or the witness to, recognize. There are complementary activities that people tend to mix with this, but they are not this eyewitnessing. For example, showing huge amounts of photographs of the suspect or making kind of portraits, but those are research activities, not so much recognizing, because to have this eyewitnessing is when you know that there is a suspect. But in many systems, the victim or witness is asked during trial if they recognize the person within the room. But what's the problem? I'm going as fast as I can. I'm sorry. I wish I had more time to talk to you, but let me just give it you all in a nutshell. Science tells us that rates of error are huge, even in the more sophisticated procedures. And we also know, and well, you have the data. I mean, they're here. We also know that the show-ups that are not so sophisticated don't have better rates of error, possibly even worse. And we know as well that there is a nil or really very thin correlation between kind of being totally sure and accuracy, okay, in this moment. So yeah, I say 100%, yes, I see that. It's not correlated with the accuracy of the recognition itself. So, as I say, there is a huge amount of research. I mean, for 2014, more than 2,000 experiments were carried out. If anybody wants to update, go to read a report of the National Academy of Science of October 2014. It's Identifying the Culprit is the title. And it reviews the main science available, and it more or less updates what it is that we know, at least to date, a few years ago. So then, indeed then, if this eyewitnessing activity is not really reliable, even when it's done properly, well, of course, they should have an important impact on the fact of sentencing innocent people. And yes, indeed, it seems to be the first factor explaining the fact that innocent people are sentenced. We have the National Registry of Exoneration. The figures there are lower. It has to do with the differences between the 2 databases. But there's an important factor that we see in near misses. In my research and anecdotal evidence, I mean, everywhere, there's a lot of information. There are cases everywhere where people have been sentenced because of eyewitnessing that went wrong. Near misses in Chile, 30% of the problems were all on bad eyewitnessing. And serious problems. I mean, sometimes people spend years in prison, and it was only because somebody was not a good eyewitness. And look, this is horrifying. We also know that the fact that not so much that somebody recognized the author, but that is not a guarantee of accuracy. In the database of Garrett, he was able to determine that 36% of cases, well, more than one witness has identified the culprit, and sometimes even 5 or 6. And you'll see why this happens. I can't kind of go into why is this so, but believe me, and there's a lot of literature saying it, this has to do with problems we have of visual perception and the way our memory works. I think that the systematic manner to analyze this is with the organization of the subject in the way Gary Wells put it. So he distinguishes between two types of factors or variables that have an influence on the system. Factors of the system. This has to do with the procedures in criminal justice for identification purposes. What we know now is that if procedures are not rigorous, there is a significant increase of the risk of actually having not reliable recognition, and this has to do with previous activities on how the procedures have been designed, how the procedures are administered, and how they are recorded. Quickly, an image in Chile. So what I discovered in my research is that the two eyewitness typologies used are show-ups and photograph set. Yeah, the typical classical traditional system you see in films is marginal in Chile. And what are the problems I uncovered? Well, that these photographs, well, and there's such a problem because there is a lot of subjectivity. Yeah, well, they make the errors be huge. And in photographs, so show-ups problems and photographs, serious problems as well. For the photograph recognition to be valid, it's important that the victim defines the person that is going to be identified, because that has to be the basis, okay? The basis to select the photographs that will eventually be useful for identification purposes. But I discovered that in 50% there is no previous description. And in those where there is a description, the description is more about clothes and not so much about facial traits, which of course is of no help whatsoever. Then of course there's a lot of subjective communication, the understanding of the police agents of contact with the person. They say, yeah, I mean, you've got to help someone identify someone. So then for the victim to identify someone, and they kind of, they are transmitting more information than they should. And this possibly means less rigor. And then problems as well as how one organizes the photographs, number of photographs, quality of photographs, and so on. Then some common problems, well, very precarious recording systems, and proceedings are badly written with scant information that makes it difficult to continue from there. And secondly, well, not following scientific guidelines such as double blind, because a civil servant administering the process, I mean, should not know the suspect, because even unconsciously he or she could give clues for identification. And what about estimation variables? Well, what Wells understands here is the whole set of factors present in the moment in which the victim or witness is codifying, observing, and retaining in memory data for posterior recognition. I call them given factors. It's what you have, right? For example, the distance, luminosity, time, the level of stress of the victim. So, well, we can't work on this much. We can't give more light to get the proximity to change. But what we can do as a system is that we have to be in circumstances in which we can gain access to this information to better assess the evidence and give it the value it deserves. What happened in Chile? Well, the format in which this is done, the declaration of the victim or the civil servant, is not working. Direct examinations are poor. There's very little work of prosecutors to strengthen reliability of recognition. And when prosecutors ask about these elements, they are mostly those that science says are not reliable. For example, how sure is the witness, the number of people recognizing the culprit, or was it during a trial? Because, I mean, when the person has been recognized 7 times before, well, it doesn't seem to be so important then that he or she says, I recognize the person now. And then also counter evidence. But I did see that there are failings there. There are not many counter examinations, and they have problems because they don't follow scientific guidelines. I was surprised in that there are practically no counter examinations regarding the lack of double blind, only 16% in the sample of cases I worked on. What about assessment? Well, once again, judges give important weight to evidence, to expert evidence. But when I analyzed the sentences to see the criteria, I saw that they're very heterogeneous and really non-reliable criteria, such as, really not very solid. And they also went to analyze the quality of the recognitions taking place in sentences. And I see that judges tend to cut and paste the arguments of the parties, and then they do it in justifications that are very, very brief. So draw your own conclusions. 7 minutes more. What to do? Well, first of all, I think an important finding is that many of the risks I described are happening in my country. And this goes on to pose important questions in compared right. I mean, never mind the typology of the system. It would seem that research is telling us that contemporary criminal systems or criminal justice systems, they're not working as they should. And here we should all share data and see if we can reach some kind of solution, right? In my opinion, the only way to solve this problem is with a and we mentioned it during the first day of the conference, but with a complex set of public policies that work at different levels. And the tool that us here have for reform is not the main one. Really, I can't go into it. I've not got time. It's a pity, right? But this has to do with strengthening institutional training, not only judges. It means strengthening the professions that are helping out on evidence, for example, strengthening the institutions, for example, the labs, introduction of technology as well, and train for that, because there's a bad application of technology sometimes, as happens with recognition. And then with Jordi, we were talking about it the other day because of the question he posed. It's essential to have public policies that strengthen specialization of human capital and scientific production in our discipline. Little is known in our countries of how all this works. I mean, it's research done in other countries, transferable to our countries. And I'm showing this only because there's so much more. But the reform, the procedural reform, is there, but really the tool for procedural reform is not what is most important, really. But I'm going to play a role here. And with this, I wish I could tell you much more, but I'll just drop this here. A legal reform can generate some impact if it goes to key nerves, so to speak, of the system. There are many nerves, but one that bothers me and is linked to other findings of my research is that despite all the problems I described, and despite the fact that the reform in Chile, as in most Latin American countries, happened at an institutional moment in order to analyze the quality of evidence and then filter it, and in many countries they call it an intermediate audience. But what I discovered is that this is not really filling in a role of filter or screening, and it's just a corridor. So anything submitted goes through. And this is owing to a number of reasons: cultural, political, environmental. Because, for example, in Chile, and I guess in many other Latin American countries, the same thing happens. There is this idea that all the problems of evidence are of assessment and not of admissibility, to a great extent with the idea that the professional judge can solve this during trial. But there's a lot of evidence saying that this is not exactly so, right? Then also because of a wrong understanding of a basic principle, which is probatory freedom, yeah? A principle according to which, in principle, any means for the production of evidence can be incorporated, and this has been seen as, the possibility of any type of evidence entering the system. Only in those cases of non-compliance with guarantees, but really anything in gets to the end. And I mean, that is because there's a bad understanding, and the legislations do have ambiguous regulations. And in a way, as there's no culture of serious screening or admissibility, things are not happening that should. I mean, I've worked for many years in a number of different countries, and I know that it's not only in Chile. The answer is always, we don't have resources. This is painstaking, time-consuming. We don't have sufficient resources to go on about admissibility of evidence. But really, I don't think that is such a problem. I really think that we could go to better screening and to analyze admissibility. So how can we contribute towards a legal reform? I'm not as naive as I might seem, and I think that a legal reform has important limitations. As you might see, my work is law society. I'm not, as I said, a philosopher. I don't know why you invited me here, really. Only because Jordi likes me, maybe, I don't know. But anyway, I know perfectly well what the distance, the huge distance is between law and reality, and how the legal reform has huge problems to change reality. And I have read a bit in my life, and I know about the compared experiences that show that it's extremely difficult, even introducing admissibility and control rules. It's very difficult. There are huge difficulties in order to have important filters. And there's not been an impact, really. For example, in expert evidence, we have a number of people who've analyzed this, and then eyewitness identification in the States, Manson versus Braithwaite. Okay, and there have been changes. So I know about the problems, but where is there a chance? Where do I see possibilities occurring? Well, I think in the political value and in the sign that a legal reform would mean in the scenario I just described. I don't think that we're going to have a change of direction substantial enough unless it's a change of legislator. So that is what's so interesting, yeah? I mean, this political value, the opening up of spaces that can be taken advantage of by people, I don't know, judges, for example, that are beginning to perceive the magnitude of the problem. And another possibility has to do with the fact that thanks to the efforts, sometimes with a limited impact, in compared studies, nowadays we know that there are some things that are more useful than others. For example, part of the problem, and with this I'll close, well, Wells describes it in a recent publication. Well, maybe the problem that has existed in the US to have a filter of admissibility for eyewitness identifications that are not really reliable is because the mechanism has been exclusion. So either everything goes in or nothing goes in. And Wells says something very interesting. He says maybe the problem is if a judge thinks that this eyewitness identification has something good, well, then the judge doesn't rule it out. But let's be more intelligent, says Wells, and let's talk about limited exclusions or specific inadmissibilities. Maybe this would generate a greater space for discrimination. I leave it here, and my apologies to everybody, but I mean, a legal reform should go to these 4 things on the slide, but as I have no time whatsoever, and I do want Q&A, I'll sit down, and that's all. Thank you.
Thank you very much. So now we are going to have a first round of questions. So we have one here, and then here. So first round.
Mauricio, felicitaciones.
Mauricio, my congratulations for your presentation. It's been very amusing, but not only that, the content is magnificent. I congratulate you, and I have been for a long time, for this empirical work that you carried out. It's essential. And I would say to other people, follow your example. I have so many questions, but I'm going to just ask you a couple. The first one has to do with a kind of counter example you gave at one point. When you interviewed the judges said, parties are not giving us the information we need. But at the same time, it would seem that judges don't know what information they actually need. So how can we know that the parties are not complying properly if judges don't really know what it is that they want to ask the experts, or what is the information exactly that they need from the experts? Second question, and this is, well, we've talked about it already, yeah, you and I for a long time. It has to do with empirical evidence and the training of judges. Yeah, empirical evidence of the inability of judges to assess properly the expert evidence. I don't know if there's any more, but of things of yours I have read, empirical studies that you quote have to do with juries, not with professional judges. And as to juries, you mentioned empirical studies that show or seem to show that these juries are not able to adequately assess the expert evidence. But there's also an accumulation of empirical studies showing exactly the contrary. So I don't know whether there are new things that have been published, or what do you mean when you kind of suggest that, or you question the disability or inability of juries because they don't They can't assess the expert evidence properly. And in the same direction, I'm interested in the last things you mentioned about the incentive among judges if there were a legal reform for them to adequately or more rationally deal with expert evidence. And I was wondering whether this inability that we tend to refer to is maybe related with the perverse incentives that most of systems have that allow judges and even incentivate or foster judges to make decisions on the basis of irrational criteria regarding their assessment of the expert evidence. But then if this is the case, I don't really see how a distinction can be made in an empirical study regarding the inability of those judging without referring to the ability and the incentives of the system for adequate fulfilling of the job. Thank you. I'm Juan Falconi from the Catholic University of Guayaquil in Ecuador. And, well, more than a question, which I don't have, I just have a very brief comment. The work that you submitted this morning is really exceptional. I think it's a great guide. And it's also a great motivation for those of us that work more on civil subjects and not so much legal, because the judicial error, at least in Ecuador, allows by constitution to sue the state. And I don't think that happens only in Ecuador. I think that that possibility is open in other countries. But the types and numbers of errors that you showed us with solid and efficient statistics and analysis has not been detected in the same way in civil areas in Ecuador. Maybe a starting point would be to have statistics about the admission of different resources. And listen, it's not so much a question what I'm posing here, it's a comment, because you gave us motivation. You make us want to start research in not only in criminal procedural law, but also civil, because obviously errors maybe might be worse in their consequences in penal procedure, but I mean, it happens a lot in civil areas. And it's not so much the error, but corruption that is the huge problem. Professor Tarufo was giving us an example in his presentation. So, as I said, it's just not a question. Congratulations.
Thank you. Adrian, you had a question? So, here, first line. Okay.
I'd like to congratulate Dr. Mauricio Duce for his illuminating and extensive research. I've just got 3 questions of clarification. Number 1, whether your research was only concerned with mistaken convictions. What about mistaken acquittals? Secondly, what do you mean by near misses? And thirdly, do you regard, according to your research, your findings, do you regard psychological evidence on reliability to be increasing or decreasing the risk of error? Whether psychological evidence of reliability increases or decreases the risk of error, whether it makes it higher or lower.
Okay, thank you. So first, so now Mauricio, if you'd like to answer, and then we'll have another round of questions.
Parto con la última pregunta, que las tengo más.
I start by the last question. No, my research is wrongful convictions, not wrongful acquittals. That's been my focus. The other, of course, is more difficult for me to do research on, but for the same reason, I wanted to clarify it at the beginning. It's a very, very important subject for criminal justice systems. Near misses, well, it's a nomenclature that maybe is not so correct, but I had to be able to label it, and I explained it at the beginning maybe too fast, and I apologize to the interpreters because I don't know, I speak fast. He does, indeed, believe me, we couldn't breathe. So anyway.
Sorry about that. Pero por near misses.
But anyway, near misses, well, the category there is cases in which there is criminal prosecution against a specific individual, man or woman, or many, not only one. And these people are I mean, they have this pre-trial imprisonment, don't they? They are put in prison before the trial, or the restrictions of their rights for quite a long time sometimes. And then they are acquitted or overseen. I mean, the system doesn't kind of condemn them. But what I mean by this, somebody could say this is a success because the system said they are not guilty. But listen, no, not at all. In many of these cases, we knew that from the first day or day 2 or day 10, not on day 1,000. And that is just as harmful for that person. The same as if somebody goes to prison for 1,000 days, be him or her guilty. I didn't really understand the third question. So why don't we talk about it on the way out? It's because the sound here at the panel is bad. But let's talk about it later. And then as regards the comment, thank you. It's good that I motivated you. I do think that civil areas have different paradigms, and we should actually see how we measure error. And some other logics operate there. And Carmen, all the questions are very interesting. Listen, a clarification. Let's see, the easiest. How do judges know that they are not given the information they need if they don't know what they need? Listen, the reaction of judges is much easier. Direct examinations and counter-examination are bad, and they realize that it's poor. Not because they say, but listen, why aren't you asking more? Or they realize that there would be so many things to ask about, but that this doesn't happen. It's that understanding, and that's what judges describe. Not so much, that's what they describe, that they perceive that things are not as they should be. Then in your other questions, there's a kind of supposition. I don't know. I didn't say it. I never talk about the inability of judges. What I say is that there are problems in that the judges find it difficult to adequately assess. And these problems have to do with a lack of training and basic understanding as to what it is that they have to solve. And here, well, I mean, there are many countries. I mean, Canada, for example, has had many problems, and it's not only where juries are the exception, it's always professional judges, and in many other countries too. It's not only juries I'm referring to, not at all, but even the authors that criticize things I say, and these the foundations of evidence law, I mean, they say that a lot of research is saying that there's no significant difference of reasoning between juries and professional judges. So I think that the distinction between jurors and judges is not so relevant. Professional judges are relatively lay people, like a juror, regarding some very professional thing. Maybe a lay person who's an engineer would understand science much better than a lawyer, or than even a judge. I've had conversations like this with quite a few judges, right? Telling me very candidly and openly, that's so great. I've been 25 years working in Chile, and as I don't participate in the trials, they tell me a lot. So judges telling me that for years they've had problems understanding expert evidence that they only came to understand 10 or 15 years later because nobody ever explain things to them properly. So they thought that something that the experts were saying meant more than it really did, or less. So I think that there shouldn't be such a difference, really, that they should be trained. And then incentives for reform and perverse incentives, well, I didn't have enough time, and I had asked the technicians to leave the final slide on the screen. You can't solve this only with specific admissibility criteria. Do we have the slide? Well, could you put the final slide before my email? Well, the slide before the last, then, please, please, please. Anyway, but this has to do with admissibility or admission criteria. I have a bad memory. I keep forgetting everything. Wait a minute. Let me have a look. Yes, it has to do with special admission criteria to better regulate the consequences of non-compliance. And thirdly, and this is crucial, you have to generate conditions for the admissibility criteria in Latin American countries becomes something really serious. We don't have the institutional conditions. Why? Because there's a lack, an absence of clear rules and guidelines that make it possible to analyze evidence properly. We need adequate times for preparation and other incentives. In Chile, for example, a problem, but I didn't include it, is that judges talking to me, I mean, you have those of oral trials, and they think that their workload is much worse. And they say, well, why should I? Has to correct. There have been some problems because in oral trials, the judges think they're more important than other judges in other types of cases. So we have to work on this. I don't know, am I answering your questions?
We have now 3 questions here, so please can you bring the microphone Here there's many questions, so I try to take as many as possible, so please keep it short. Thank you.
Hola, hola, Mauricio, muy...
Hi, Mauricio. Here, over here. Very brief, especially in your last slide. What I see is that errors are always faster than the detection of errors. So, errors and mistakes happen, but they are not detected till quite a time has gone by. So what happens in Chile about preserving evidence? Because the detection of errors and mistakes, and in the US, there's work done on this, and they are linked to the possibility of re-examining evidence. So then you have to preserve the evidence. And I don't see you mentioned it, or you didn't even consider it as part of the legal reform for Latin American countries, where there is bad preservation of evidence for a re-examination later on. What about it? Thank you. I'm a criminal judge in Ecuador, professor, and for me, what you're talking about is so interesting. Chile has really been a reference for the legal reform in Ecuador regarding the criminal procedure. And concerning expert evidence, if it is not well considered, and this happens with judges, they tend to, it is true, overvalue the exclusiveness of the testimony of the expert. It's not an obligation, that it's not mandatory that the expert writes a report following scientific and methodological guidelines that could be demanded. That is not demanded. And Professor Gascon, in fact, told us in her presentation that that would be a means to guarantee quality of information given by the experts. So in your research, I would like to know, what do you suggest in order to improve this distortion that there is between, this excess importance given to the experts' evidence, and then what about the reports of the experts? Thank you, Mauricio. I really liked your presentation. But I had a doubt, specifically concerning how we can detect that there has been a judicial error. Well, what happens is that new evidence comes along showing that the previous decision apparently was wrong, and then we revoke. And we have to assume that the new evidence that emerged and the way it is assessed has been correct and adequate. So then the error happened the first time and not the second. So if this is the answer, then we have an immediate paradox, don't we? Because in order to be able to know whether there has been a mistake, in order to be able to criticize a certain kind of evidence and the way in which the evidence has been assessed, we have to use the same kind of evidence and the same way that that evidence was assessed. So in order to criticize the system and detect the errors of the system, the support and foundation is the same assessment and the same foundation. It's like kind of shooting your own foot. Let's see, the first question. Yes, I said to you I'm going to only go to one nerve, but this is pending in Chile. The preservation of biological evidence rules are very precarious. That's part of the problem. But of course, this would only solve a small percentage of cases in which there is biological evidence, and we are told that, it's a minor percentage. In our countries, many of the crimes are against property with some degree of violence. And there, you don't get this kind of biological evidence preservation, but yes, we can work on it. For the Ecuador judge, yeah. There is this indication of having to submit a written report, and we have it written as to when it should be handed in. There are clear rules as to how it should be written, but with the adversarial logic of our system, what is finally given in is just the expert coming along. He or she is interviewed about the report, and then the report can be used because the expert brings it along to refresh his or her memory, or just to show contradictions or controversy issues. So yes, the duty is there, it's been described, and we have it, but usually the written report is never received, only the oral declaration that happens during the trial. Daniel, I don't know whether I understood your question. I'm not so much concerned about the epistemological and logical dimensions, remember. What I'm concerned about, and let me say it this way, it's not so much error, but the practice. I mean, I would say that an eyewitness identification that doesn't comply basic science or bad evidence is something I don't want to have in the system, never mind when it generates error. So I need less evidence for the issue I want to talk about. That's why you invited me here, really. I mean, my life is not wrongful convictions of but better said, how do we improve probatory practice? I don't know whether that answers your question, but I'm positive.
Three questions enlisted, one here on the fourth row, then Jordi, and then Gary Edmonds.
I think that what Mauricio Duce has talked about is very important also with the knowledge of Carmen Vázquez. This is something that happens in my country, Peru. In 2012, I was lucky that I listened to Professor Tarufo about this. And, well, of course, what happens is that the criteria required, and I'll only talk about the problems we have in the assessment of expert evidence. I could talk about many other probatory issues, indeed, but I'll only talk about expert evidence in Peru. 2 years ago, in 2016, the public ministry established a protocol to change the way in which psychological expert evidence must be given in sexual offenses. Remember that we are linked to Spanish jurisprudence a lot in Peru. So we have linked jurisprudence, one in 2005, where we said for the sexual offense declaration to be valid, 3 requisites have to be complied with: uniformity, non-perverse intention, and peripheral evidence. So if a woman says she's been raped, well, and the culprit says no, well, then the prosecutor will go ask the police, and then eventually psychological tests will be carried out. And sentence is 30, 35 years. There's no reduction of sentence. So then in 2016, before that, the psychological test was a 30-minute survey. As of September 2016, the World Health Organization has established rules, DSM-10, that forces 4 hours. And there are different tests carried out. In September 2016, then something new came up, that the experts of the public ministry, the forensic office, well, they have to be proper professional psychologists. But the problem is that in the forensic office, we don't have all that many professional psychologists. And before, when it was a half-an-hour interview, well, we had problems in time. But now with 4 hours, as there are no more psychologists and nothing has improved, well, then there's a backlog. We have a terrible problem. We don't have enough personnel to carry this work out. So, of course, the result is not going to be very good, and the evidence is going to be very poor. And then the judge will have to decide. So, of course, in judicial power in Peru, in the year 2016, I believe, we had a linking jurisprudence to start working on this psychological expert evidence and on medical and legal evidence, because of course, I'm coming to an end, but I have a suggestion. I mean, Tauber, I don't know what you talked about, and I mean, if Carmen accepts it, if not, we shall see, but on the basis of the expertise, this could be replicated in other countries. In all Latin America, we have the same problems. If we want to improve the quality of criminal justice, well, then we don't want serious errors to happen, especially on the basis of expert evidence. So it would be good for people like you to work in all the different countries. Well, when I talked about this, in Peru they said, well, how can we do anything if we are a poor country in Peru? We don't have resources. And, well, those of us who are judges in Peru have tried to do some work on legal medical examinations. And we said that 2 things have to be taken into account. Who is the expert, and in what way was that expert evidence obtained? There has to be a protocol. And I mean, you mentioned it, that very often it's very young graduates that come along first. In Peru, we have that happening too. And of course, yes, I'm sorry, I think more people have to ask. Yeah, the question then, how do we go about implementing what you've done? Could you collaborate with us? No, let's talk about it having coffee. No, but could you come along to Peru? And Dr. Carmen, I mean, could we get a master in more countries in Latin America so that we can detect all this? So a lot of work has to be done.
Jordi.
Muy brevemente.
Very briefly. Don't promise what you can't meet. I will. The main aim here is to confirm I like you. You're a great guy. And as I have the microphone, well, I have a suggestion that wasn't part of your presentation and shouldn't be, but possibly it's one of the best things that we can do as jurors. We can have to improve the situation. Let's change the bloody programs that we teach in law faculties. Let's change the curricula. As long as this is not part of what is taught to undergraduates that are going to become lawyers, prosecutors, and judges, the understanding of probatory problems is never going to improve, ever, even if kind of more or less good laws are passed.
At the end of the back of the room, there's Gary Edmond who asked for one question, and then we will leave the floor to Mauricio in the back of the room.
Photograph. My family asked me to take a picture. If I don't send it, I have a serious problem.
So two comments. The first is that I think almost all of the studies of juror and judge capabilities have never really asked them to assess the evidence in conditions where they could rationally evaluate it. It's always been presented in kind of quite artificial ways and never with the kinds of information that peak scientists have advocated as being essential. So they don't normally get error rates, performance in similar situations. So it doesn't really matter. They're not meaningful assessments. I don't know why or how they're evaluating evidence. I'm sympathetic to admissibility standards. I do a lot of work myself. But then some colleagues and I did a study of 4 jurisdictions, the UK, the US, Canada and Australia, looking at their admissibility standards for expert evidence. The UK and Australia have very weak admissibility standards. The US and Canada have quite demanding admissibility standards focused on reliability. And what we found is that it made no difference. Admissibility standards in our jurisdictions allowed all the same evidence in. So America allowed the same evidence that Australia, which doesn't have a reliability standard, in. So you have to be careful there. The interesting thing, just as an observation, and it suggests the importance of culture, which you're not questioning, is that the only time American judges seem to be concerned about admitting evidence is in civil litigation, where conservative judges, mainly appointed by Ronald Reagan at the time, were willing to exclude evidence in these civil cases where they were concerned about too much litigation, an insurance crisis, and a situation where there are civil juries.
Okay, thank you, Son Mauricio. You have the floor.
See, I agree completely with you. I probably said too fast, but my idea is I'm not have a lot of expectation, but rather to send a political signal, and I think we can learn precisely because of the experience of that. And also the first point, then we can talk. I know that there's some problems with the evidence. Pepe, muchas gracias. Conversémoslo.
Pepe, thank you. Let's talk about it. But just one thing out of your argument, this idea of the fact of us being poor and then whatever comes is okay, this is just something we cannot accept. I'm sorry. In our countries, okay, we're poor, fine. We don't have many resources. But let's talk about the level of demand. But not to demand anything at all is morally unacceptable, politically wrong. We can't just say, oh, we have no resources, we're poor. Does that mean you can sentence people willy-nilly and just do it any old way? Listen, we've invested a lot in prosecutors, judges, and procedures. We've spent a lot in our countries, however poor we may be. So really, I don't think now we can say, yeah, we need $3 or 3 pesos to improve the system, then we let anything and anybody in. No way, no way. We have to attack this. And I hope that this kind of evidence generates this kind of discussion. And Jordi, yes, I fully agree with you. Yes, I was quick when I talked, but yes, when I analyze training programs and the institutional training, I'm including all dimensions. And that's why I insisted this is not only a problem of the judges, all the actors intervening, even the non-legal actors have a responsibility and deserve to be trained. In the Chilean case, I'm critical. I mean, to be a judge in Chile, you have to go through the Faculty of Law, then there's a competition to get a kind of examination. Yes, there's a public examination. Then you go to the Judicial Academy. There you spend a year doing law again, more exams on law. And then judges, once they have been selected as judges, every year or every X time, they have law courses to perfect their knowledge. Huge resources. They are taught nothing about eyewitness identification, for example, nothing about science. So come on, this is crazy, isn't it? I mean, no, we have to change this in our culture. A judge needs as much of this as, as of the other. So if I have 5, 7, 10 years training in law, I mean, I could do it at home with the internet. So why don't we go for other courses, giving other tools that traditionally had not been considered? Possibly this has a lot to do with where we come from. This was perceived as non-relevant in the past.
Well, thank you very much. I would like to thank all the panelists this morning. I would like to thank specifically Mauricio Duce and all of you for your question and discussion. I apologize to all those that would like to ask questions and had no time for this. So thank you very much. And now we are going to have lunch. Thank you.